Jai Hind to all of you. Welcome to Malhotra's IAS. So the Parliament is finally, it has tabled the new data protection law bill, and also there are certain petitions going on across the high courts in the country which deal with the right to be forgotten. So both of these things are interlinked, and in this video we are going to understand what exactly is the right to be forgotten, how is it linked to the new data protection bill which is being discussed in the Parliament right now, right? So let's get started. The first thing is that what is exactly right to be forgotten. Now you see that since most of the things right now as far as an individual is concerned, they are digitally present, the online presence has increased manifold, and that is where the right to be forgotten comes into picture. When we particularly talk about the right to be forgotten, that basically deals with the concept of the right which an individual has to exercise control over his data which is present online. That certainly is of utmost importance to an individual, the personal data which once you happen to upload on the internet, but right now you think that you need to exercise your right of maybe to withdraw that data, to delete that data. So that deals with the right to be forgotten, right? And certainly to control your own life would also encompass that you have the control over whatever is your existence on the internet. So pertaining to that existence which you might be having on the internet in the digital domain, over that also if you want to exercise your right, that is related to the right to be forgotten, right? So we are going to discuss in detail about this thing also. So exactly when we talk about the right to be forgotten, that is any public information or any information pertaining to you as an individual which is available in the public domain, right? Including all the sources, maybe it could be present on Google, it could be present on either of the social media handles, the social media platforms, and certainly that personal information right now you deem it no longer necessary to be present there, right? That is, it is just pertaining to you, but it is not serving any other cause. So that is no longer necessary or relevant for that information to be on the public domain or on the internet, and it falls within the ambit of your right to privacy as well, that you as an individual certainly have the complete right to withdraw that information, right? But what should be the condition? That it should only be pertaining to you, and it is no longer necessary or relevant for that information to remain in the public domain or on the internet. So how is it linked to right to privacy? See, as far as right to be forgotten is concerned, it is inextricably linked with the right to privacy. Even in the Justice K.S. Puttaswamy judgment, that is, the case was Justice K.S. Puttaswamy versus the Union of India, the Honorable Supreme Court had said that right to privacy is an inherent part enshrined in Article 21. That is, the right to have a dignified life also means that you are able to protect your privacy, and that entails the privacy which is in the digital domain, which is across the internet, which is over the social media platforms, right? So what previously the Odisha High Court has also said, and now even the Delhi High Court, right, that is also disposed of a particular matter where two businessmen have filed a petition seeking to invoke their right to be forgotten, right? So if we just talk about briefly as to what have been the previous few verdicts, then certainly you see in one particular verdict, the Delhi High Court had said one Mr. Joravar Singh Mundi. This is the particular case of Mr. Joravar Singh Mundi. This gentleman, he had a particular case filed against him from which he was acquitted, right? But when he happened to go to the United States of America, and when there he was looking for a job, the first thing which his employer did was just googled about his whereabouts on the internet, and this particular case just cropped up. from which he was already acquitted, he was, proven not guilty, but still this was the track record which was present on the internet. And he then approached the High Court and said that since I have been, acquitted of this case, but still my past is haunting me, and that such a past which does not even hold true as of date, right? Because I was declared innocent by the court. So he said that please ask the search engines, Google in particular in this case, to remove all these things from their own search engines and their databases, right? So the High Court certainly agreed with him and gave a favorable verdict for this particular individual. But that is just one case, right? There are millions of people today, rather there are trillions of people today across the world who have all of their information available on the internet. And certainly the other countries, the other continents have also included or also enacted laws pertaining to right to be forgotten. Fine. So let us now move to the particular bill which is right now the point of discussion, right? The government right now, the matter which we were discussing, which not this particular Joravar Singh case, but another case of two businessmen who have filed a similar petition in Delhi High Court, where the court and the central government, they have had exchange of views, and the central government has responded to the Honorable Delhi High Court that the matter or the bill which the parliament is going to discuss, the data protection bill, that contains provisions regarding the right to be forgotten, right? So this says that the right of data principles chapter and its provision right to be forgotten, they are going to be enacted by the parliament, and the data principle, that is the person concerned, the one whose data is being talked about, whose data is there on the internet, right, shall have the right to restrict or prevent the continuing of the disclosure of the personal data by a data fiduciary. Now the question comes up, what is a data fiduciary? See, any such entity which is in the control of that data, any such entity which is having control over that data, that can be termed as data fiduciary, right? So it could be Google, it could be Facebook, it could be any other entity for that matter. So that is what the contention from the government's or the government's viewpoint is. Now when we talk about the status of the current bill, so it was introduced way back in 2019. Then onwards it was referred to the one of the committees of the parliament, and now the report by the joint standing committee, this was the JCP, that is the joint committee of parliament, to which it was referred, and 16 December 2021 is the date when the committee had given its report, right? The committee has already given its report, and we are going to take a look into briefly what are the recommendations that the committee, the joint committee of parliament has made, right? So first things first, when we start talking about the joint committee of parliament on the personal data protection, that is the technical name of the committee, that has already, it has conducted very wide deliberations over a very long period of time, 78 sittings, 184, more than 184 hours, and now the report has been tabled in Lok Sabha and Rajya Sabha, and they have in all made 99 recommendations, particularly of which there are 12 which are related to the bill. जो ये 12 recommendations हैं particularly, they are related to the bill, and some are in such grave nature, and or you can say some of the recommendations are of such grave nature that they are trying to, or they have already twisted the very nature of the bill, right? So let's quickly take a look at what are the recommendations. So first thing, the key recommendations we are taking a look at by the joint committee of parliament regarding the data protection law, which might see the light of the day very soon. So first is the transition period. What exactly the committee said regarding the transition period is that since there is going to be a lag from the date of notification of this particular law, and how the complete ecosystem, that is all the companies, the corporates, even the governments, they are able to respond to it, that is they are able to gear themselves towards adopting or implementing the procedures enacted by this law. So they be given at least up to 24 months to ensure that all the data aggregators, they get ample time to comply with the provisions of the act, and this 24 months time, mind you, is going to be from the date of the notification of the act, right? Whenever there is a bill that bill is passed duly by both the houses, then that bill goes to the president. Of course, you must be knowing that after the president gives his or her assent, then that bill becomes an act, and after that the government notifies it. So what the committee has suggested, that after you have notified, from that date of notification, give them up to 24 months so as to be able to comply with that. Then what they have said is that 9 months from the notification of the act to all the data fiduciaries should be given who deal exclusively in children's data. Now that is certainly even more significant, right? So that is the difference between the data fiduciaries which are completely dealing with or exclusively dealing with the children's data. Now moving to the next thing is non-personal data. Now you see, earlier what was there was suggested that the personal data of an individual and the non-personal data, they are going to be handled separately. But now what the committee has suggested is that it says that non-personal data and the personal data should be included in one such big umbrella where you club them, you do not see them separately. Why they have said so is that because they said it is almost impossible to distinguish between the personal and the non-personal data, right? At times it becomes this task becomes almost impossible, and that is why they said that when you are transporting that data or when you are collecting that data, then practically speaking it is almost impossible to, you can say, isolate the two, right? So what has been suggested by the joint committee is that all such data should be held by or should be dealt with by a single data protection authority. Okay? Basically this data protection authority, if I as an individual, if tomorrow, for example, let's say if tomorrow this right to be forgotten is given through this new bill or through this new act, data protection act, then what exactly it envisages is that I as an individual who wants to invoke my right to be forgotten will have to approach this data protection authority and tell them that these are the details which once at one point of time I shared on the internet, but now I want to discontinue their disclosure on the internet. So they will look into the matter and they will then assist me invoking my right to be forgotten. So this is what the clubbing of the personal and non-personal data has been suggested by the joint committee of parliament. The next thing that is on the cards is basically with respect to social media and the liability of the social media. The JCP says that the social media that plays a very significant role in today's age, they should, these platforms, the JCP say, do not act merely as intermediaries and they should be treated as publishers of information. What exactly do they mean by this? They are trying to pinpoint the responsibility, or they are trying to pin down the responsibility on the shoulders of the social media intermediaries also, who are not just intermediaries as according to the view of the JCP, but they must be held liable for whatever is the content that they're hosting, right? These are certainly no holy cows, mind you. These are big corporations which are minting huge amount of money, right? So at the end of the day, the buck needs to stop at some point, right? Chaliye. So this can be debated, but yeah, that is what the recommendation has been. Then there's a recommendation for timely alert, that if at all there is a breach of the provisions of the law, right, and the data has been compromised, then any fiduciary which is there in the picture, that is the intermediary or the authority which is having control over that data, or the data aggregator, must notify the data protection authority, the DPA, within 72 hours. Okay, that is what the recommendation has been. Then after that, it is that data protection authority in whose court the ball will be, right? They will decide upon as to what is the severity of the breach and what will be the appropriate remedial measure which has to be taken. But certainly there will be at least a body in place which will be taking care of if at all there is a breach, right? So that is the time aspect of it. Because see, what happens in our case is that mostly होता क्या है कि जो है time निकलता रहता है, आपको बता दिया जाता है कि हाँ अब इस पे कार्रवाई हो रही है, but precisely अगर एक time frame, if you fix a time frame, then that is certainly better for the betterment of the citizens' rights only. Okay, so then apart from that, there has to be some amount of penalty also if you do not comply. Then a fine of up to rupees 15 crore or 4% of the total global turnover of the firm has been suggested for any breach on their part, and apart from that, a jail term of up to 3 years if any de-identified data is re-identified. मतलब ये है कि once if you have provided that this particular data should not be disclosed or it should be discontinued to be on the public domain or on that particular website, or for that matter that fiduciary or that data aggregator, right? It could be a social media entity as well. So if that data that has been de-identified again reappears or it is re-identified, then you could face a jail term of up to 3 years, right? So certainly that is going to have some kind of bearing on the mind of these data fiduciaries, right, to implement the provisions, to uphold the provisions in all earnest. Then why is it needed? You might be wondering कि इतना सारा, why is this all fuss about the data protection bill, it being referred to the committee of the parliament, then the committee taking so long a time. Apart from that, various high courts, Odisha High Court, Bombay High Court, the Delhi High Court, witnessing cases regarding the right to be forgotten. So you see, for this also, the Joint Committee of Parliament gives us some very strong points. What they say is that there is a sense of unease which is prevailing in the general public कि ये जो companies हैं जिनका data daily basis पे, minute by minute basis पे, rather second by second basis पे, हर second data आपका जो है, that is going to WhatsApp, that is going to Facebook, that is going to Instagram, that is going to Twitter, and so on and so forth. So the general public, in the general public, there is a sense of unease कि भाई ये जो सारा डेटा है वो कंपनीज किस तरीके से हैंडल कर रही हैं, दैट इज ग्रोइंग, राइट, दैट सेंस ऑफ अनईज इज ग्रोइंग डे बाय डे. Apart from that, the rapid commercial use of personal data that has also resulted in the undermining of end user trust and confidence. You simply do a Google search regarding any of the products. What you happen to see is that next day maybe your mail is flooded with this, relating to the products or by the companies which are engaged in that particular business, or maybe you start seeing advertisements whenever you open any other web page regarding that particular product which you once happened to search. So what is actually happening is that all your data presence is being monitored and accordingly the data is being used, right? Then there are certainly concerns of misuse, and the sensitive and critical personal data is particularly vulnerable to misuse, right? And that is where this is rising exponentially. एक बात तो है कि your personal data, it is certainly prone, it is vulnerable to misuse, right? We have all seen about individuals being impersonated, and in their data, in their particular IDs or in their biometrics, in their names, certain fraudulent transactions being made, right? And this is rising exponentially, right? Then what exactly is the committee saying here? The JCP has said that now this has led to a conclusion that now it has become, it is crucial to build what a legal, cultural, technological and economic infrastructure for a secure and user-friendly data ecosystem. Now these could be very crisp points which you can use in your mains answer writing as well, right? That certainly this is what is the data friendly ecosystem which right now the JCP suggests we try and build through the incorporation of the provisions which the JCP has suggested to be included in the data protection bill, right? Okay, so I believe until this point of time this is clear to you. Now moving to some of the global standards and a comparison over them. So this piece of information courtesy the Indian Express, they have beautifully compared the Indian law and the law which prevails in the European Union, right? So there are much similarities, like the consent clause, certainly the user's consent is very much required. That is one such similarity between the law which prevails in the European Union and the one which is there in India. Then supervisory authorities, the data breach has to be notified within a period of 72 hours, right? And that is also the case with the Indian law. Here you also you have the provision of 72 hours within which the data protection authority needs to be informed. Then they provide for a 2-year transition period for provisions of the GDPR, that is the data protection right in there, European Union. Here we have provided for 24 months and 9 months, as we have already discussed, so I'm not going to into the details right here, right? And similarly is the case with the data fiduciary, that it is any natural or legal person, public authority. Similar is the case with India also, but here mind you, they have, in their definition of what is a data fiduciary, that is any body which is having substantial amount of control over your data. In the Indian law, we have also the JCP has also suggested that you please include the non-governmental organizations also. जो NGOs हैं उनको भी include किया जाए in this definition of data fiduciary. All those NGOs which are dealing with the collection of data of individuals, right? Because they also have substantial amount of data at their disposal. So that is with respect to the similarities. Now, if we talk about the dissimilarities or how these are basically different from each other. So the principles of data protection, they do not apply to any anonymous information such as non-personal data. Whereas what we are talking in the case of India, the Joint Committee of Parliament has said that non-personal data, we have already discussed, must come under the ambit of data protection law. So that is the first stark difference between the two laws as there in the European Union and in our Indian case. Then no jail terms have been mentioned in their particular case, but we do have included a jail term of up to 3 years, right? So that certainly can, देखो simple सी बात है, the laws, any country for that matter does not take up any legislation from any other continent or any other country as a one size fits all approach, right? This has to be custom made, this has to be tailor made, so that can be certainly accepted. Fine. So coming to the, almost trying to conclude this video basically. So there are already academicians who have started questioning that whether this is a fine balancing act between the right to privacy of the individual on the one hand and the right of the state to intervene, citing maybe national security, unity of the country, integrity of the country, right, and compromising upon the privacy of an individual and his data privacy included in that. So already there are comments that they say that whether the data protection bill, which is yet, mind you, which is yet to become an act, but already there are, apprehensions that it heavily tilts in the favor of the central government and against the fundamental right to privacy. So is it actually the case? Well, some of the provisions of the bill, they definitely suggest so, but we'll have to wait for the final act to come into being. But nonetheless, one such provision which gives you a hint that this act, whenever it becomes an act, it might be tilted in the favor of central government, is that the power of the central government to exempt departments from the application of the Data Protection Bill 2021. So that means that the executive by its own discretion can give exemption to its agencies or to its own organs from the provisions of the bill. So that means that even if you might be a data fiduciary, though you are controlling or having substantial control over the data and you fall within the definition of a data fiduciary, but still you will be exempt from the provisions. So what does that mean? That you simply give a complete blanket immunity from the application of the provisions of this particular law to most of the government agencies. ठीक है, तो वो एक जो है बन सकता है कि एक ये डाउन साइड हो इस लॉ का. फिर जस्टिस BN श्री कृष्णा हैज ऑल्सो मेड सम ऑफ द ऑब्जर्वेशन कि ऐसी एग्जेम्पशंस जो हैं दे आर डेंजरस trend and they are potentially leading to an Orwellian state, right? That is a state becoming the almighty. Apart from that, any exception, please mind you, any exception has to be, it has to be limited and it has to be precise. कि अगर exception है किसी भी rule के लिए कोई, तो वो limited हो, precise हो, pinpointedly mentioned हो. Otherwise, it is always going to be prone to misuse by the authorities, right? So let's just let the act becoming, let's wait for the bill to become an act, and only then we can say what are the provisions which have already been discussed here and debated are becoming an actual part of the law. And then we'll look at it and we'll take another opportunity to deal with and discuss with all the provisions of that law as and when it becomes an act, right? So until then, keep watching, keep learning, stay safe, and I'll see you in one such another video. Thank you and bye-bye.